Good morning, Texas. I know we've got folks showing up from all facets of our great state of Texas. I'm glad everybody was able to join today. We are, of course, virtual. We've been going virtual since COVID. So I'm sure everybody's learning. Y'all may have become Zoom go-to-meeting team gurus by now, knowing how to operate, host, and all that good stuff. We've got a great team with our firm as well who's helped us along. I know I'd probably have a few problems here and there if not for them. So thanks as always to Kyle, Lindsay, and the other team members with our firm. If you don't know me, my name is Clint Brown. I'm a shareholder with our law firm. I'm not going to say the name. It's really long. I'll do the acronym, though, RMWBH. And today I'm going to be talking about neighbor-to-neighbor disputes. It's such a wonderful topic to discuss. This is a CE-approved course, continuing education. So if you are a manager and you need that education credit, you get an hour today. There should have been a little click mark whenever you were registering. You needed to click it, and then we take care of the rest. So we'll send you that certification after this presentation is over. Give us a couple days to put all the data together, and you'll get that certification so that you can represent that you attended. Now, does that mean you need to attend? Yes, it does. So you've got to be on this call and listen to me for the next hour. But if you need the credit, it's a great opportunity, and it's going to be a fun topic. We'll have some fun today. If you have questions while you're going through, just click on that Q&A button down at the bottom of the screen, type your question in, and then Kyle, one of my team members, is going to be interrupting me as we go through the course to say, "Hey, Clint, you got a question," and then he's going to relay the question so I can answer it. Now, before we get going, here's something new I got. It's a COVID-19 Knowing Your Risk put out by Texas Medical Association. It's kind of fun to look at the different risk levels. Going to a bar, that's high risk? What? No. Movie theaters are up there. Anyways, if y'all are interested in that, you need a copy of it just for your own knowledge. Just look it up on Texas Medical Association. That's it I'm going to be talking about for COVID today. Hopefully, y'all are probably a little burned out with it. So let's get right into it. Okay, so neighbor-to-neighbor disputes, whether you are on the board, a manager, or whether you're just an owner in the community, you probably very much aware of the neighbor-to-neighbor disputes. Unfortunately, it can get a little petty, and it can get a little aggressive. Owners getting very angry at one another. And when that neighbor-to-neighbor dispute starts, it really severs a lot of ties between the neighbors at issue and can really just make it difficult for those neighbors to even live in the community anymore. I mean, pretty simple neighbor-to-neighbor disputes we've seen escalate out of proportion and causing neighbors to actually move, just get up and move. They may even stay in the same community association and just move a few streets over because they have that much of an issue with their neighbor. So the question is, how do we seek resolution? How do we get it done? Most of the time, hopefully, the association doesn't have to get involved and the neighbors can work it out amongst themselves. Common issues we see. We've got a laundry list here. Fireworks, the old barking dog. We've got a dog barking at all night, all hours of the night. I can't get any sleep. We're getting new barking dog complaints during the day now. Why? Because everybody's working virtually, right? A lot of people are now working from home, getting their job done at home, and when they hear the next door neighbor's dog just yapping nonstop, it drives them a little crazy. So you as a manager or a board member may be getting those more often now due to the kind of the working at home, the remote office. Parking, kiddos in the street, boundary disputes, noise, view, water damage, especially common with condominiums, and then of course aesthetic concerns. Man, whatever they're doing over there is real ugly, manager or board member. Y'all need to do something about it ASAP. So what do we do? Here is the typical language for the right to enforce. Most board members and managers, y'all are probably well aware that the board, the association, has the authority to enforce its deed restrictions. You can find it in the restrictions. There is also support for that enforcement right in the Texas Property Code. But what a lot of people may not realize is that your declaration may also give a right of the owner to enforce the restrictions against another owner. And here's some sample language. Shall inure to the benefit of and be enforceable by, so these people can enforce it by the association and every owner, including declarant. So when you're in developer control, the declarant, and their respective legal representatives, heirs, successors, assigns, et cetera, et cetera. So this clearly says that the association has the right to enforce the restrictions, but also every owner has the right to enforce the deed restrictions. Now, this doesn't mean that owners can enforce other provisions like levying fines, doing the self-help remedy, all that kind of stuff. Typically, this language only gives the owner the right to enforce the restrictions against another owner through a demand letter. Do we like owners to do that type of enforcement? No, we typically don't. If it's an owner-to-owner dispute, we always recommend that they try to just kind of work together, speak with one another to seek a resolution. And we're going to talk about some other resolution options. But if it gets to the point where owners are sending demand letters to each other, more than likely, if there is a lawsuit by one owner against another owner, unfortunately, that owner is probably going to be suing the association as well, saying not only is this owner in violation, but the association had a duty to enforce the restrictions and they didn't comply with that duty, so we're suing the association too. So we try to avoid situations like that as much as possible. Why? Because you don't want to have to get an insurance defense attorney involved to deal with it. All right, so extent of the issue. How bad is the problem? If it threatens the health and safety of others, then it's something the association is probably going to have to get involved in very, very quickly. It may involve what's called a cease and desist letter if it's sufficiently egregious, and the attorney's going to have to know about that ASAP so that he or she can get the letter out quickly. Possible depreciation of property value. If it's something that's going to depreciate property value, more than likely it is a violation that the association is going to be able to enforce. Depending on how egregious it is, you can either do your normal deed restriction enforcement process, which is a courtesy letter, maybe followed up by one more letter, and then a 209 letter where you're threatening to start levying fines, assuming, of course, you've got the fining authority. You've got to have the authority to fine in order to fine. That authority must be located where? In your declaration, your bylaws, and in your articles of incorporation. One of those three documents. Articles, we tend not to see it very often. It's usually in the bylaws or the declaration. But you cannot just make a rule. You can't pull a fining policy or a fining rule out of thin air just because you want to. It's got to be located in one of your core governing documents. All right, and then finally, disturbance to multiple neighbors. So we've got Fluffy the Yapper next door, and we only have one owner complaining about little Fluff Sparks. That's probably not going to be enough for the association to get involved. That is going to be an owner-to-owner issue that they need to try to fix amongst themselves. Now, if little Fluffy, we get complaints from, all the neighbors in the area complaining about Fluffy, well, it gets big enough where the association can start taking action. We'll talk about how they take action here in a little bit, but again, check the restrictions. duty to enforce versus discretionary authority. So for enforcing your restrictions, is it a duty, or does the association just have the power? So it's duty versus power. A duty is something you shall do. You don't have any kind of discretion. It's has the duty to enforce the restrictions. It's prefaced by the words has the duty to, shall, must, all those words prefacing enforce the restrictions. That means you've got an obligation. You've got a duty to do it. Now, a power is something different. A power is something you can do, but are not obligated to do. So it's discretionary in nature. It is prefaced by the words has the power to, may, can, but is not obligated to, and then whatever it is, and in this case, enforce the restrictions. So understand whether or not you've got a duty or it is merely discretionary. Possible violation of the covenants. Again, if you're dealing with a violation and it's fairly clear, then yeah, you can enforce the restrictions. Failure to act could create some liability potential for the association. We're going to talk about that, especially in the realm of the Fair Housing Act and some HUD information that came out, I think it was 2016. And then finally, other considerations. Is it the best use of community funds? Look, we may be dealing with a community that doesn't have a lot of funding available for enforcing restrictions, and you've got to pick the more egregious ones to enforce. The ones that are less egregious, maybe you've got to just send e-blasts out to try to get people to comply, follow the rules, all that good stuff. So what kind of funding do you have available? And then finally, do you have community support, or is everybody against it? I'll give an example here. Everybody's aware of the BLM movement, right? The Black Lives Matter movement that's really kind of gotten a lot of national attention and national support. And it's, everybody wanting to be treated equally with, Black Lives Mattering and everybody being treated equally so that everybody's aware of the concerns that we've been experiencing across the nation. Well, with that, y'all have probably seen a lot of BLM signage pop up, the Black Lives Matter signage. A lot of the signage is worded well. It's not inappropriate or derogatory. Some of the BLM signage, unfortunately, is very derogatory and uses bad language and makes threats. And that type of signage, I think, the association should work to get it removed. But let's go through the hypothetical here. We've got a community association that is a no-sign association. The only exception to the no-sign rule is for sale or for lease signage, and then political signage. So state law protects political signage. So certain political signage for runoffs and all the votes we recently had across the Texas counties, all that is protected by state law. So political signage is okay. And then most of the time the restrictions allow for sale or for lease signage as well. Let's assume those are the only two types of signs that we can have, political and then for sale or for lease signage. And then we've got BLM signs popping up around the community. Technically, under the restrictions, those signs are not allowed. So what do we do? Should we enforce right now? Our recommendation currently is, look, let's pump the brakes. Let's give a little bit of opportunity for people to kind of express themselves on this BLM movement. But at some point in time here in the near future, the association, if it's got the enforcement authority, is going to have to start considering enforcing the no BLM signage in the community. Get with your council to come up with a good game plan if y'all are experiencing that in your community, but you've got to be fair and consistent, right? It's got to be no signage anywhere. Right? You can't have the, my son is a recent graduate of XYZ school. You can't have that. You can't have the cheerleading signage up. You've got to be fair and consistent in your signage removal if that is the route you want to take. But again, topic for another day. I could probably spend 30 minutes discussing that, but just a little bit of a sidebar. Kyle, do we have any questions so far?
We do have a few questions, Clint. So first, what about if the dog you were referring to on the last slide bites someone and gets loose frequently?
Okay. So we've got the dog biting somebody, whether it's another animal or a person. Number one, the police have to be called immediately, right? So the person that was injured, they need to call the police. You've got to tell them to call the police. We are not the police. It's not our job to do that sort of action. So police have to be called immediately. Number one. Number two, do we have the authority to do something? Is there some sort of do we have a leash law restriction in the community? And if the answer is yes, and we've got good narratives, then absolutely the association can take action. But in conjunction with that, the owner who was accosted or injured has to take action as well, because it's gotta you gotta go both avenues. So the answer is, if you've got the authority to do something about it, yes, you should do something.
All right. We have another question here. So what if the violation issue was in 2019 between two neighbors on a post and gate mounted to her fence, and now she cannot get out, but is just now complaining to the association in summer of 2020?
So when did it start again, Kyle?
2019.
You were good. Yes, the association can get involved if it's a clear violation, and we've got good pictures and a good narrative from the complaining owner. And again, we've got the authority to do something, right? You've got to have that authority, assuming you check all those boxes. Yes, the association can take action. And the thing to think about is the 4-year statute of limitations. So we've got 4 years to do something about it. There is a discovery rule that could extend it. I won't get into that discussion, but yes, the association can take action, assuming you've got the authority.
All right, one more going back to your last slide. So there's a condominium owner who has several guests stay in the home for long periods of time, and they constantly wake multiple neighbors with arguments, yelling, sometimes pounding on the walls. The police have been called multiple times, once arresting a guest, but the nuisance continues. So they're saying the rule is that nuisance noise, etc., is not allowed, but there seems to be a question as to how involved the board or management company can be and what they can do to minimize the situation other than issuing fines. And so is there anything else the board could do?
Yeah, so, again, assuming we've got a good deck of evidence, right, a lot of good information, the association can send their demand letters as assuming you've got fining authority. It's a condo, so I'm sure it's there. You levy fines, send your letters, turn it over to the attorney to try to get that going. But if you are getting a response from the owner who's engaged in the alleged nuisance, if you're getting a communication from them and you're getting a communication from the complaining owner, maybe we can look into some sort of mediation option where the association doesn't necessarily have to be involved, but they go to a dispute resolution center for the county where the property is located. And we're going to talk about that here in a minute. So that could be an option.
All right. There's several other questions that we'll wait for a little later in the presentation, because I think you're going to cover several of them in the presentation.
Perfect. All right. Thank you, Kyle. Okay, so Fair Housing Act. This is the other issue we're going to be discussing today. It prohibits discrimination based on the classes that you typically think of when you think of discrimination. So race, color, sex, national origin, familial status, religion, and disability. So there's a neighbor-to-neighbor dispute and it somehow involves one of these protected classes, you may have to take a certain level of action, and we'll discuss that here in a minute. Okay, so changes to the law in 2016 basically subjected community associations to possible liability if we have the authority to do something and we do not do something. And we'll get into that a little bit more here in a minute. Okay, next slide. All right, nuisance provisions. These are the catch-all. Most of the time, when we're dealing with a neighbor-to-neighbor dispute as it relates to behavior, so not structural neighbor-to-neighbor disputes or, basically animal getting out and you've got a leash law, but it's basically complaining because of barking dog or loud parties, banging around, all that kind of stuff. Most of the time, the association if it decides to get involved, right, it's sufficiently egregious, you've got good evidence supporting it, relies on their nuisance provision. It is called kind of the catch-all provision. And here's some sample language that we like to see for nuisance provisions. Unfortunately, a lot of nuisance provisions are weak, and we'll discuss that in a minute. But no noxious or offensive activity shall be undertaken on any lot. Or you can't do anything that may become an annoyance or nuisance to the neighborhood or surrounding lots. Lots, plural. So again, barking dog. If it's one neighbor complaining, that sounds more like a neighbor-to-neighbor issue that the association should not get involved in. If, however, it is affecting multiple lots, then the association may be able to jump in and use nuisance to try to get compliance. As you can imagine, subjectivity is a big concern. It is very subjective. It is kind of the eyes of the beholder problem that you run into. What Bob may think is a nuisance, Jill may think is fine. So that's why it's so important. I keep hammering this. It's so important to have solid narratives, good pictures, all that kind of backup if the association decides to take action, because again, it's subjective. It really is. And as long as we have some really good evidence backing us and neighbors who are willing to testify, if you've got to go the court route, then I think we'll be okay. So that's where the investigation comes in. You've got to determine whether or not it's got some merit or it's baseless. Okay, let's move on to the next slide. Fining authority. Got to have it. We've already discussed it, right? It's got to be one of those core governing documents. So your declaration, your bylaws, or your articles. Can't pull fining authority out of thin air. It just doesn't work that way. And fines are really used as leverage. They should not be considered an income stream, right? Don't include it on your budget as some sort of income stream. Don't fight tooth and nail to keep the fines on the account if the owner has complied with the restrictions and fixed the issue. Use it as a negotiating tool to encourage them to comply and fix the problem. Be consistent in your waiver of fines, but remember, fines are what are called a soft cost. There is no real hard cost associated with the fines, so you've got to be flexible in waiving them. And you've got some conditions precedent or precedent, whatever you want to call it, before you actually institute fines. Chapter 82.102, or excuse me, section 82.102 of the Texas Property Code applies to condominiums, and you've got to send a certain letter for condos before you can fine. And then 209, chapter 209 of the Texas Property Code also has a 209 letter you've got to send before you do some fines. So 209, chapter 209 applies for single family and certain townhome communities, and then chapter 82 is for condominiums. Next slide. All right, mediation. Here's what I was discussing. Mediation could be an option. If the association is involved, then maybe it goes into an association and violator mediation, right? So the owner or owners complain to the association. The association gathers all the evidence, sends a demand letter to the violator, and then the violator and association, either with or without counsel, decide to go to mediation. Well, who do we use? One of the most cost-effective options is county dispute resolution centers. Most counties or areas in Texas have a free or significantly reduced rate mediation center. And it is the association getting together with the violating owner and a mediator in the middle to try to reach some sort of resolution. If it's sufficiently egregious enough, the association's probably going to want counsel present to assist in getting this thing taken care of. You go in with your position as strong as you can, but when you come out, you've got to understand that you're not going to get everything you want. You've got to be willing to have some wiggle room in there so that you understand exactly what you're going to get out of this. And the big goal for deed restriction enforcement is to fix the issue, right? Fix that violation. Try to come up with a good solution to fix the violation. Fines and interest and, you know, to a lesser extent, attorney's fees, you should go in understanding that, hey, if we can, you know, waive some of these to get compliance and get an agreement, then let's do it. Number one. Number two, you want to designate either one or two board members to be your representative who goes to this mediation. And you do that through either a unanimous written consent or you do it through board action at a board meeting. But designate one or two people to have full authority to resolve the problem at mediation. You don't want to have to be going back and forth to the board members who aren't present at the mediation to get their opinion and vote. You want to have that full authority because crazy things happen in mediation that you really don't necessarily anticipate. So it's important to have a good plan in place and have somebody who has the authority to settle the matter. Again, issues that are appropriate: nuisance, neighbor disputes, real estate disputes, etc. Modifying existing court orders, not okay. Child support, yeah, we don't have to deal with that. Criminal matters, divorce matters, those are not appropriate. And this is kind of what county dispute resolution centers, these are typical, you know, green light and not green light issues. So even if you're not related, you know, even if it's a non-association related item and you're just a board member or a manager and you're running into a problem, keep that in the back of your head. A dispute resolution center may be a good way to fix the problem. All right, when to contact an attorney. Parties aren't getting along. It's sufficiently egregious. You've got a violation of the covenants, very clear violation of the covenants, and you've got good evidence. We're unsure of our duty to enforce. Contact the attorney. He or she should be able to get you an answer within 10, 15 minutes, right? It's going to be a pretty quick response, so it shouldn't be too expensive in attorney's fees to figure out whether or not you need an attorney to get involved. Complex property. Yeah, if you're dealing with something very complex, easements, boundary disputes, all that kind of stuff, you're going to want to get an attorney involved because there's some nuances and legal jargon and legal concepts that, you know, the layperson isn't expected to understand. So you need a real estate attorney there to really dig into the issue and assist in resolution. And then finally, the Fair Housing Act issues arise, and we'll be getting into that in a minute. All these is pretty much when you need to contact an attorney. Number one. Number two, look, if we're your counsel, our law firm has this kind of 5-minute rule. You can make a phone call, talk to the attorney at our firm, and if it's a 5-minute phone call, we're not going to bill you for it. Just ask us the question. If it's a 5-minute phone call, you should be fine. So don't worry about that if your attorney is with our law firm. Next slide. Any new questions, Kyle, popped up that are relevant to the slides we've hit so far?
Oh, I've seen a couple. So we have an interesting one here about shared fencing issues between, this is in single family associations, between owners and the responsibility. And, you know, what happens when an argument breaks out as to an owner not wanting to pay?
Well. The old shared fence problem. We run into these all the time. So if it's a fencing that abuts the common area, we can obviously take action and get involved. Why? Because everybody sees it driving, right? Or walking if it's behind. Everybody sees it, so we can take some action. Same thing with the front yard portion of the fencing. The association can get involved and take certain action. Why? Because the neighborhood in general can see it. We need to make sure our community looks aesthetically compatible in compliance with our restrictions. Now, side yard fencing in between two lots, right? That's one we usually don't want to get involved in. That is a true owner-to-owner dispute, and owner one is not willing to pay for the cost of repairing or replacing fencing from owner two. You know, owner one may have a small claims action, so can actually bring a lawsuit in small claims court to get a judgment against the offending owner who's not willing to throw in their fair share. Hopefully it doesn't come to that. That stinks if it does. It's just completely unfair, but the association doesn't really get involved in those types of situations, or we don't recommend they do. Why? Because if you did that for 700 home community every time a problem arises, you wouldn't have any money left in your operating account, because getting involved in that kind of a dispute costs money, and it's just not worth it most of the time.
All
Anything else,
right.
Kyle?
Yeah, we got a couple more here. So kind of coming back, or a little more with that question, here's another one. So what if the dispute is over an easement area that doesn't belong to the association, and neighbors want to place their trash cans in the same spot, but neither own it?
Oh, that's a tough one. Man, trash can wars. Geez. That sounds pretty silly to me. I don't know that I'd want to get involved in it. You know, maybe if a board member could have a chat with the complaining owner and be like, look, guys, come on, let's act like adults. That's a silly one. I don't think I'd get involved or want to get involved in that one.
All right. And then do two more basically separate noise issues, but are both kind of interesting. One involves wind chimes. You know, what happens when the governing docs have provisions on barking dogs and construction, but nothing else? And, you know, you got wind chimes that are a problem. And the other one is there's an older owner in the neighborhood who is always has their TV up super, super loud, and other people can hear it, but the owner says this is the only way they can hear the TV.
Man, these are good ones. I'm surprised we haven't had the doggy doo-doo nuisance yet. But in relation to the wind chimes, if we don't have any good authority we can hang our hat on, and maybe, you know, maybe you've got to get your council involved to try to find a way to fix it, then we can't do anything. If you don't have the authority to do anything on the noise, then you can't do anything. Can you send a, hey, you know, try to stop your wind chimes letter? I suppose so, but look, I've got wind chimes in my backyard. You know, unless they're these monstrous things that are just really loud and you've got multiple neighbors complaining, it's probably not something you should get involved in. The other one with the TV being really loud and the guy says that's the only way he can listen. I mean, I'm pretty sure they make those amplifiers that you pop in your ears and it allows you to listen better. So that sounds like an excuse that's not valid. So if you've got multiple people complaining about the noise and you've got a noise restriction you can enforce, then yeah, that guy needs to maybe, you know, spend $30 on something. I saw a made for TV item that was $20. So it's, you know, it's not like it's a very expensive way to fix the problem. All right. Attorney's fees, they're there. We can get them. Let's move on. Next slide. Okay, here we go. HUD's new harassment regulations. All right, this one is the one I've been hinting at, where if one owner is complaining about another owner harassing him or her, and it is sufficiently egregious enough, and it relates to one of those protected classes, right? Gender, race, national origin, familial status, disability, then HUD is requiring the association to take some sort of action if they have the power to take that action. So let's get into this. This is a tough one for associations. Next slide. All right, here's one type of harassment: quid pro quo harassment, an unwelcome request or demand based on a protected class. And it is a, you know, the request or demand must be acquiesced to in order to sell, rent, or make the housing available, sale or rental, provisions or services. So unless you do X, I am not going to give you Y. So quid pro quo, we see this most often when an owner is making a request and then a board member, an ACC member, or a manager does some sort of quid pro quo harassment. So let's get into some examples here on quid pro quo. Requiring an owner to perform a sexual favor as a condition of ACC approval. Unless you do X, I'm not going to approve your ACC application. Again, way out of bounds. If this ever happens in your community and you're either a fellow ACC member and you hear about it, or a board member or a manager, get your attorney involved ASAP. That is unacceptable in any way, shape, or form. Muslims current conditioning a Muslim resident's use of the pool on her not wearing a burkini. Not okay. You are again discriminating based on a protected class. Quid pro quo. You can't use the pool unless you agree not to wear a burkini. And then finally, telling a resident that a nuisance restriction will not be applied to his party as long as he doesn't invite a minority, whatever the minority group is. Again, not okay. Discrimination, quid pro quo. These are all very specific examples. Why are they so specific? It's because we have had to deal with all three of these. These are all very specific examples that our law firm has had to address. So they seem way out in left field, right? Hopefully most of the people on this PowerPoint or presentation see this, and yeah, it's way out in left field. Never do this in a million years. Unfortunately, we've got associations that have done it. So quid pro quo, that's one type of harassment, and that directly involves the association. Okay, hostile environment. So this is kind of the work environment, unwelcome, protected class, and again, different things. So let's, next slide. Okay, so we've got to ask the question, is it severe enough or pervasive enough for the association to get involved? The examples I just went through, obviously severe and pervasive enough for us to get involved. So it all goes down to the nature of the conduct, the context of the incident or incidents that the owner is describing, and then severity, scope, frequency, duration, and location. Is it just one incident? Is that enough? Or is it a pattern, multiple incidents over and over again? And what is the relationship between the two people who are involved? This is where you've really got to do some good fact gathering. The complaining party has to give you a very good narrative. And look, if there's emails involved, they need to provide the emails. They need to give the association all the information it can so that the association can make a fair determination. Counsel should be involved as well. Okay, next slide. And here's some examples. Harassment is so severe it causes a resident to move away. Sexually suggestive comments or offensive touching on a repeated basis, or it could be, you know, severe enough for a single basis to be good. Just racial slurs frequently, and graffiti, going home, or ethnic slurs. Again, house for sale by owner because my neighbor's a not okay, that kind of signage. Who can be held liable? The person, right, who's doing the harassing obviously can be held liable. The association, if it's, you know, a ACC member, a board member, a manager, or an employee of the association if you've got employees, all held liable. Contractors, if there is an agency relationship. So we get word that one of our contractors that we've retained as an agent, i.e. the manager, is doing something, we've got to take some action. Liability for third-party harassment. So the association, the association has no relationship whatsoever other than the fact that these two people live in our neighborhood. We can be held as a third party, so for a third party's harassment, if the association knew or should have known about the harassment, i.e. an owner's complained and has given us really good information and a good narrative so that we can make a determination. Number two, we had the power to correct the problem. We had the power to do it, i.e. we've got to have restrictions that are strong enough for us to take some strong action. And then we failed to take prompt corrective action. So those 3 items must be present. Number 2, had the power to correct it. If we have no power whatsoever in our restrictions, no nuisance, offensive language, that kind of restriction, if we don't have any of it, do we still have the power to do something? I think we've got the power to send them a letter, basically a softly worded letter saying, hey, we don't tolerate this kind of action in our community. We don't tolerate discrimination in our community. Please stop. If we have zero authority to do anything, that is probably the best letter we can put together. We really can't do much else. Why? Because we have no cause of action to file a lawsuit, because we don't have the power to do anything. But should we send a letter? Unfortunately, yes, we should. But the association should be aware that we can get challenged by the violator, number 1. And then number 2, we don't have the power to do anything other than send a letter. And it's not even going to be a strongly worded letter. And we've got to be aware that, it may turn into a he said, she said type situation. But can we send a letter? Yes, we can do a certain level. Do we have to send a letter? HUD is a little unclear. However, one of the attorneys with our firm, she is actually working on a paper on this very subject, and there is some case law indicating that we may have to do something, send that one letter. Now, if we've got a very strong nuisance provision that gives us the authority to do things, then absolutely we can have a more strongly worded letter. And yes, we do have to do something in accordance with HUD regulations. Next slide. All right. So training for association personnel and agents. Again, if you use a management company, the management company probably has some training videos and everything that they've already had, that they have their managers do or listen to. Harassment reporting policy. We don't see that too terribly often, because hopefully harassment is we don't see it often. But look, if we're in a community where we see it, a few times a year, a month, something along those lines, then maybe a policy we need to think about doing. Evaluating the association's authority to respond. Again, we've got to have that power. That's why it's important to get an attorney involved when we get harassment that rises to discrimination. And it's got to be pervasive enough. It's got to be severe enough. There's got to be a clear link to the harassing behavior and a protected class. It can't just be, oh, Bob's been picking on me and calling me stupid every day. That's not enough to trigger that protected class. And so, again, that's why it's important to get your attorney involved. And then look at all the social media stuff. If it's floating out in social media, then maybe we can use that for enforcement. And then coming up with a good way to respond, working with your counsel to do that, because we don't want to get in trouble with HUD. All right, if a fair housing complaint is filed, so Fair Housing Act, what happens? We've got a very, very, very short time frame to respond to the complaint. So the minute you get it, manager or board, get your counsel involved ASAP, because they've got to jump on it. Gosh, what's the timing? I always have trouble with this. I want to say it's 10 days, but don't quote me on that. Mediation invitation. Hey, look, maybe we can get it fixed via mediation. Everybody sitting down with a mediator to try to fix the issue. Requesting information. Get as much information from the complaining owner as you can. On-site interviews, preliminary determination, rebuttal evidence. All this is when there's a formal complaint filed, and you've got to get your counsel involved. Hopefully he or she is familiar with responding to Fair Housing Act complaints, because there's a very strict time frame and different information you've got to provide the agent who is working on the complaint. Next slide. Oh, here's our summary. And good, we've got a little about 15 minutes for questions. They're frequent. you're always going to have to be struggling with them as a manager, and you've got to have a balancing act, right? When to get involved and when not to. And if you're unsure, get with your counsel. He or she may be able to allow you to bend an ear to give you thoughts on how to proceed. Most of the time, hopefully, it can be an owner-to-owner resolution, so the association doesn't have to get involved. If we do have to, well, then maybe we act as kind of an intermediary, kind of a middleman to fix the problem. Fines, mediation, covenant enforcement, and attorney assistant, all options to try to fix the problem. And then if you decide not to act, make sure you reach out to counsel if it's something that is a little bit of a touchier subject, to make sure you're doing the right thing. And if you've got counsel who's recommending you take action, I think it's probably a good idea for you to take that action, that recommended action. Next slide. I think we may be done. Yeah, questions. So let's roll into the questions. Kyle, do we have some more coming our way?
Oh, we got lots of questions today.
So boy.
Thank you to everyone that has submitted questions. All right, we'll start with what we've just covered most in the last couple of slides, Clint, and that's with the harassment in HUD. So I have a question here. So is the burden of proof on the complainant?
For
harassment?
Yeah. So, burden of proof, yes, we've got to have enough evidence to be able to look at it and make a fair determination on whether or not to take action. So the complainant has to provide us with the information. They can't just say, oh, my neighbor is using racial slurs against me. It's just, that's not enough, right? You need a good narrative. You need dates. You need times as much as you can. And when it gets to that level, I recommend making sure your manager is in the loop and probably your counsel as well.
All right. When you're speaking on the third-party letter, is that coming from the manager or attorney?
Typically comes from the attorney.
All right. Another one here on HUD. It's ask, is it 10 days to respond to a HUD complaint?
Yes, I think so. But while we're asking, I'll do a little research for you. What's the next question?
All right, so we're going to go back to nuisance neighbors. So what about nuisance neighbors that have filed for bankruptcy? Can fines and letters be sent to them?
And it is 10 days. Good. I was right. Say that again, Kyle.
So nuisance neighbors and the association knows they filed for bankruptcy. Can they still be sent fines and letters if they're being a nuisance?
They can still be sent letters, fines potentially, and it depends on what district you're in. So for instance, Southern District of Texas, you actually have to make a fee app request with the court to be able to levy things other than assessments, which is completely silly to me, but there's cases out there saying you've got to do that. So really depends on the district, but yes, you may still be able to take some action, even if there's an active bankruptcy.
All right, here's another one. If there's a section in the governing documents that states owners must comply with all local, state, and federal laws, does that allow the association to enforce local, state, and federal laws with the fines and enforcement authority granted by the governing documents?
No, I don't think you should go down that road. Now, in terms of, Fair Housing Act complaints, yeah, I think that could give us a little bit more power, but again, it's still pretty weak. We cannot enforce discrimination laws on behalf of a government agency. We don't have that authority.
All right. So what happens if an owner refuses to comply to the letters being sent, and they simply state they refuse to acknowledge the notices being sent?
You can put your head in the sand as much as you want, but if it's sufficiently egregious enough and it's a violation of the restrictions, the next step is going to be a lawsuit. So they can refuse to acknowledge the letters all they want, but the association can levy fines, assuming you've got the fining authority, and or file a lawsuit. So they can ignore it till the cows come home, but we can still proceed with our enforcement action.
All right, a couple of questions here involving lights. So one, One neighbor is complaining about a porch light in the backyard being too bright. That's one question. So what do you do there?
Well, and I'm sure there's no lighting lumen lumen limit in the restrictions. Right? You know it when you see it, and if it's sufficiently, if it's overly bright, then maybe we can try to work with the two owners to come up with a solution. I actually had to deal with this with a community association in Austin, and we were able to reach a resolution. There was a lot of back and forth and complaining, but we were able to get the problem fixed. So, that's a very subjective violation, right? So, great hypothetical, but if you can't work it out between the parties, then you may have to get counsel involved, assuming you've got some good authority in your governing documents.
Yeah. So here's another one. It is a little more specific, but I'll try to generalize it for everybody. So this person has asked, how do you handle a neighbor that received approval for a modification to a house several years before, but now some new neighbors have come in and are complaining about that modification, specifically the brightness of the light? And this has, like I said, has been approved by the association several years before.
If it's been approved, it's been approved. Now, I don't know if the approval actually approved the lumens used, right? So there may be a way for the association to make the argument that, yeah, we approved the fixture addition, but we didn't know it was going to be this obnoxious in terms of light level. So please buy light bulbs that output a little bit less, or maybe we do some sort of a covering to protect the neighbor from getting blasted with the light. Again, all very subjective, but there are ways to get it worked out between the owners, and the association may have to facilitate that resolution.
All right, a few questions here about some assault allegations in the neighborhood, and the police don't want to do anything about it. Is there anything the association can do if, say restraining orders, they're right next door to each other, don't work, or another person, they're acknowledged that they're mentally ill? And
yeah, so we don't have any power to get a restraining order, right, between two parties. That's for the complaining owner to get a restraining order. That's not us. Now, the police won't do anything. I'd like to see the police reports to see exactly what's in that description. And the complainant should be able to get us a fully unredacted police report, right? Because if we make the open records request, there's probably going to be some redacted material in there. So the complaining owner probably needs to get a copy of the police report. Look at that. Do we have the authority? Again, it's the same stuff that we've gone through on this presentation. It's, do we have the authority? Is it egregious enough? Do we have the evidence we need, the police report? And if the answer to all that is yes, then yeah, we may be able to take certain actions.
all right, interesting question here, Clint. So what are the conditions protecting contact information of owners in a neighbor-to-neighbor dispute when one neighbor wants the contact information of another to be able to try to resolve the dispute?
Okay, so the complaining owner, the violating owner wants the complaining owner's information to try to fix the problem. The first thing you do is you just go to the complaining owner and you just say, hey, the violating owner said he or she wanted to speak with you to try to resolve the problem. They want to be good neighbors and do the right thing. Are you okay with that? And if the complaining owner says no, then you're like, look, this is going to get out if you want us to proceed any further on this. So we're recommending that you get it fixed and give them and allow us to give them your information, because if you don't, there's nothing else we can do about it. We're trying to help resolve and facilitate resolution, but if you're not willing to help and do your part, then maybe we can't take any other action. And again, it's very subjective. I don't know what the problem is, and I don't want to give you legal advice on what to do for this particular issue. But if you're stuck between a rock and a hard place on that, you probably want to get your counsel involved to give a little bit of give some legal advice. All
right, you had mentioned fences earlier. What about trees? If there's tree limbs hanging over fences or into other people's yards, and the owner that the lot that the tree sits on, the owner does not want to do anything about it.
Again, egregiousness, if it's sufficiently egregious enough, and maybe we've got an arborist that comes out and say, yeah, this is a very significant safety issue, maybe we can get involved. But most of the time, I would say that's an owner-to-owner dispute. We don't have a dog in the hunt, as it were. And again, how strong are our restrictions?
All right. We have another question here.
I'm giving nothing but attorney answers here, guys. I'm sorry. They're just, geez, it depends. It depends.
Yeah. So here's a question. So where on our website can we find our other webinars from the previous dates?
Kyle, rock and roll, sir.
So those are going to be on our YouTube page, which there is a link. If you, it's in the footer on the bottom of the page. You'll see the little YouTube symbol. Click on that. That takes you directly to our YouTube page where all of our previous webinars are located. And we will be happy to send out the slides for this webinar and the link to this webinar as soon as it gets posted to YouTube to your email.
Perfect.
Rest of the questions, a lot of them are kind of off topic from people wanting some other information. So if you would like to see us cover some of these topics in future webinars or in future articles, please send me an email. That's kbeam@rmwbh.com. And I'll work with Clint and the other attorneys to throw some topics around and get some further presentations put together for everybody.
All right, perfect. Well, hey, yeah, we had 4 minutes left, so we made good time today. I hope y'all got a little bit out of it, and of course, you get your CE credit today for an hour's worth of listening to me yap and yammer. So hopefully y'all got something out of it, and as Kyle mentioned, if there are other topics you want, shoot an email to Kyle. If you've got some other questions for me, and you need kind of the 5-minute freebie, please feel free to give me a buzz or shoot me an email, and I'm happy to give you my thoughts. Now, remember, you get what you pay for. I'm not reviewing governing documents or anything like that. I'm just giving you some thoughts for you to ponder. Well, thank y'all again. Enjoy your week and enjoy the rest of your day. Bye-bye.